Florida Supreme Court is now in session. Please be seated.
Our second and final case today is Caylor versus State, number 2023-0338.
Good morning, Your Honors. I'm Barbara Becheris, representing Matthew Caylor. I'd like to reserve 5 minutes of my time. Thank you. Mr. Caylor is seeking a new penalty phase trial in this matter because the attempt he made to rescind his waiver of a jury was rejected. He's seeking a new penalty phase that can be heard by a jury. I want to begin by talking about the point in time when it became clear that the reason for Mr. Caylor's waiver was no longer present. And that is the reason was no longer present as of January 2021. That is when the victim's mother in this case passed away. And Mr. Caylor did not know of that for several months. But during the months following that, he said on several different occasions when he attempted to waive a jury, as well as mitigation, as well as a couple of times his presence at proceedings, that the reason he wanted to enter these waivers was a promise he had made to the victim's mother that has been weighing on him.
Correct me if I'm wrong. I remember the phraseology of the promise, though, was about the family. It only became specific to the mother after he learned of her decease, right?
I disagree, Your Honor, with that reading of the record. The promise involved the family, certainly, that it was a promise to her that he would not put her and the family through proceedings. But when you look back, at one point he talks about how the victim's mother had, and this is going back years, had actually come to see him in person before his first sentencing, and that at that point in time he had told her that he was not going to drag
leaving all this aside. I mean, it seems to me the trouble with your position here is that the point of a waiver and the point of a colloquy before a waiver is dealing with changed circumstance. Anytime a right is waived, there is incumbent on the court and incumbent on the person waiving the right to make a decision that perhaps the circumstances will change. A waiver doesn't mean anything if it is not sort of reflective of the fact that things might change and you may come to regret that you have waived this right. It seems to me that the rule you're asking us to adopt is one that sort of takes the substance out of waiver and makes any defendant capable of saying, well, because of this changed circumstance or this postulate in my waiver, because that's now changed, it's not an effective waiver.
No, Your Honor, because the fact that changed before the waiver was even entered into. This is not a situation where Mr. Caylor knowingly entered a waiver being fully apprised of the circumstances, particularly that the person that he was trying to honor was deceased. And then later, the person tragically died, and he said, oh, wait a minute, now my reasoning has changed. What happened was that
my question is, though, I mean, regardless of the timing, isn't this baked into the cake and the determination that this was, bad faith for the purposes of obtaining a delay? If we're looking at this from an abuse of discretion standpoint, this argument was made, the trial court considered it, may have been a credibility issue that the trial court made in reaching this conclusion. But regardless, how do we remove this from the kind of global determination that this was bad faith? Wouldn't it have to be some misunderstanding of fact from the trial court's perspective?
Well, the determination that this was made in bad faith for the purpose of delay, Your Honor, I don't think is borne out by the record when you look at the chronology of when different things happened. And certainly the trial court was as ignorant of the circumstances when Mr. Caylor's waivers were accepted as Mr. Caylor was himself. So
that's really
I
the
have
argument that it has to be some misunderstanding of fact on the trial court's part for this.
Everyone was misinformed. The trial court.
But then at the beginning of the proceeding, when it comes out, your client just sits there, doesn't say, "Oh no, I don't want to do this. I want to revisit my waiver because she's dead." He didn't say that. It's months later that he brings it up. Isn't that correct?
Your Honor, my client, who was represented by counsel and who was appearing by Zoom, was taken completely aback at the news. His counsel did not say anything. The court did not say anything.
Your client's not.
The state did not say
incapable
anything.
of expressing himself, I don't think, based on the record here.
He's very capable of expressing himself.
And so
yes.
but he waited 4 months, or wasn't it about 4 months?
There was a delay of about 3.5, almost 4 months before the motion was filed, during which he had to consult with counsel. And the record does contain, Your Honors, I wanted to point you to a document that was prepared by defense counsel in response to a request for a Nelson hearing after the waivers had been accepted and not withdrawn. It's on pages 628 and 629 of the record. It's a summary of contact by attorneys and support staff, but it verifies what the record suggests, which is that there was no contact between Mr. Caylor and his counsel until immediately before that motion was filed in March. So there was.
Can you provide, and I'm sorry to cut you off, but can you provide us with an example where a defendant's misunderstanding about a fact that seems to me to be totally ancillary to the right that he's waiving, that made the waiver unknowing? Can you provide us with any cases that supports that's, maybe on all fours or similar to what we are considering here?
Your Honor, I can't provide you with an example that's on all fours because the fact here, it is not ancillary. The fact here was Mr. Caylor's entire motivation for entering the waivers, which he stated repeatedly.
How is this case similar or dissimilar from Figueroa Sanabria?
Figueroa involved a misunderstanding as to the legal consequences. Right. So that is a difference, which is why I didn't cite Figueroa as being on all fours, but I do think that it's instructive that when there is a factor that truly subverts the defendant's ability to be entering into.
But the nature of the factor would have to come into play, right? I mean, it's, in Figueroa Sanabria, it was because the trial court said something that was a misstatement of the law, right?
Correct.
Okay.
And here you have the trial court and apparently the state and Mr. Caylor all being mistaken about the fundamental reason for which he was entering into the waiver. But I do want to point out
the whole thing about a waiver is when people are going through waiving and there's the colloquy, are they asked why? Subjectively, they're waiving?
yes, sometimes.
Is that part of the standard colloquy? Like, why are you doing this?
Oh, I don't believe it's required as part of the standard colloquy, but it was completely understood here that this was why he was doing it.
But all sorts of people can have all sorts of subjective reasons for why they want to waive the right to a jury trial. And sometimes that'll be known, sometimes it won't be known. And it just seems like to accept your argument would set us off down a course where people can come up and say, my mother died after I gave the waiver, and I only waived because I didn't want to put my mother through having to watch my trial. Okay, so you get all kinds of things like that based on these subjective reasons, and that's not the focus of the inquiry about whether a waiver is knowing and voluntary, is it?
In this case, Your Honor, it should be. And I do want to clarify, we are not taking the position that an after-the-fact change of circumstances is at issue here. But this is a situation where Mr. Caylor was attempting to waive a fundamental right, a right that our state constitution says is inviolate, a right that's protected by the federal constitution, which is to have a jury decide his fate.
Yeah, I know, but I think Justice Kennedy and I are going sort of the same point I started earlier, which is waiver has to mean something. And presumably, I'm at record 572 and 573. This is the letter from Mr. Caylor to Judge Patterson of March 25th, 2022. And he's going on in his own voice about how he would have never, made the waiver and describing his mental illness, his bipolar disorder. We may not, as part of a form waiver, inquire as to the subjective motivation of a person in making the waiver. But the trial court does assure itself of the competency of the person making the waiver. So the judge makes a finding that the person is either not on any mind-altering medication or has taken his or her medication, has confirmed that the person is acting voluntarily, has been advised. These are all parts of a normal colloquy. It seems like the basis for Mr. Caylor's withdrawal or attempted withdrawal of his waiver isn't really the subjective motivation. That's in the first part of the letter. But what he really says is, I'm dealing with my mental illness and there's chaos and the medication, I'm not getting as regularly as possible. So yes, I'd like to withdraw my waiver. And the trouble with that is the decision to make the waiver on the record was supported, I'm sure, by the colloquy of the judge into the defendant's present mental status, present voluntariness. I think the rule you're asking us to adopt just makes hash of what happens when a colloquy is taken in court. You're asking us to just nullify it because of its inconvenience and the regret that the defendant later has.
Your Honor, I respectfully, I don't think giving up a jury under a mistaken reason is an inconvenience. And I don't think that the surrounding circumstances of Mr. Caylor's mental health and other things.
Do you dispute that Mr. Caylor had adequate mental status to waive his rights when he waived them?
No.
You don't concede that? You don't dispute that?
I don't dispute it.
Okay, so your position is that the waiver was voluntary, and your quarrel is with knowing, but with respect to some subjective fact, not with the consequences of the waiver.
The consequences of the waiver are, and this is I apologize, I don't remember exactly where in the record it is, but it's in one of Mr. Caylor's statements. Mr. Caylor made this waiver knowing that it was 99.9, I think were his words, % certain to lead to a death sentence, to give up a jury, which at the time did not require unanimity. So he knew that that's what he was doing, and he knew he was doing it because of a promise to the victim's mother. I guess
the point is, I don't see, and I'd really like for you to respond to the difference between a fact external, however important it may be, a fact external to the decision of what are the legal consequences of my waiver. You're pointing to that external fact. I'll give you a hypothetical. Let's say that he had made the determination to waive his rights because he had no objective belief in the afterlife. And then he found religion. And now he wants to change his waiver because he thinks he has to do some kind of thing with his life. Your rule would allow him to take that external consideration and make it part of the knowing and voluntary colloquy before the court.
Your Honor, the rule that, to the extent we're seeking a rule today, is, I don't think would go that far. It would be that when somebody has made it clear throughout the proceedings that his goal in waiving something to which he's entitled is a promise, an external promise, yes. And when that promise is impossible because of the death of the promisee and the person is not informed, then the person should be given an opportunity to reflect on whether he wants to enter into the waiver. And I want to return to that moment that Justice Kennedy mentioned where Mr. Caylor did not object at the resentencing hearing. Mr. Caylor and his counsel had no idea coming into that hearing that they were going to hear that news. And apparently, in the record, the court did not know until that date, too. There is one party that knew ahead of time, and that is the state of Florida. And the state of Florida could have reached out to counsel and given them an opportunity to have this information and to object at the hearing. They could have started the hearing with, Your Honor, there's been a material change in circumstances for my client, or not even, I'm sorry, they're not a material change in circumstance. The circumstances don't exist because Mrs. McNallen, the victim's mother, had been dead since the previous January. And the state of Florida didn't do that. The state of Florida sat there while defense counsel said, could we confirm with Mr. Caylor that this is what he wants to do? And only after that did the state of Florida say, oh, and by the way, she's dead, but we have her victim impact statement right here. So I think you have to consider that in the context of what happened in that hearing. Again, and the fact that Mr. Caylor was with counsel who did not object, and that a motion was filed apparently as soon as he was able to confer with counsel. And I just want to, I'm getting towards the end of my time, so I just want to, in addition to that, note that under the standard that this court developed in Floyd for retracting a waiver or allowing somebody to retract a waiver, yes, Justice Sasso, you mentioned the trial court's finding that this was made for delay, which I do not believe is supported by the record. Again, if you look at the chronology, but the other Floyd factors weigh completely in Mr. Caylor's favor. There was no evidentiary proceeding that would have to be undone. The only thing that had happened at the sentencing hearing was that documents had been entered into the record. And in fact, even when that hearing was closed, the court was still explicitly waiting for a state report from an expert retained by the state. So clearly this was not the same thing as somebody going through an evidentiary proceeding, the expense of a trial, calling witnesses, and then trying to change their mind. So if you look at it under those Floyd factors, Mr. Caylor should have been able to exercise his right to a jury. And if you have no further questions, I'd like to reserve the remainder of my time. Thanks.
You.
May it please the court, Charmaine Millsaps representing the state. I would like to get right to the heart of what knowing for a waiver means, because that's really the claim here, that the waiver was unknowing. And I'd like to quote from the Figueroa case, citing the United States Supreme Court case of Ruiz, and you say the law ordinarily considers a waiver knowing, intelligent, and sufficiently aware if the defendant fully understands the nature of the right and how the right would likely apply in general. You're quoting the United States Supreme Court there. Your Honor, the knowledge that you need for a waiver to be knowing in the legal sense is the knowledge surrounding the right you're waiving. What this would have to be was some, as happened in Figueroa, some misinformation regarding the right at issue. At here, somebody would have to say this claim to be really having anything to do with what we mean by knowing would have to be a misapprehension or misinformation about the right to a penalty phase jury during a resentencing. This allegation doesn't even come close to this. There's a complete disconnect between what you need to know for a knowing waiver and this claim. It's quite frankly, the mother's death is in terms of whether the waiver was voluntary is completely, it's a non sequitur legally. The misinformation has to be connected to the right you're waiving or the consequences of the right. Here, what he would have to be told is what a penalty phase jury's purpose and role is, and then the consequences. For instance, here the consequences would be this would turn into a bench penalty phase where the judge alone would make the factual findings, where typically if you had a jury, it would be in conjunction with the jury. None of this is a complete non sequitur. I would also
I agree with your argument. And yet I am curious whether the state did in fact know about the mother's passing prior to the colloquy during which Mr. Caylor waived this right.
Well,
was the state aware of it?
The prosecutor must have known before he walked into the penalty phase. Your Honor, I can tell you, I do not know is the answer. Normally, we find out from the victims when some proceeding is coming up that the victim's going to be part of, or a major stage of the case. It's a few weeks before that. So just from my own experience, I usually find out about whether or not the victims are going to come to an oral argument, for example, just a few weeks before the oral argument. We contact them, I think, 4 or 5 weeks before. So I suspect the prosecutor only knew before the November penalty phase a few weeks, but there's nothing in this record about that. However, that's not Brady.
When did the waiver happen?
The waiver was in May. The waiver colloquy?
Right.
Yes, the waiver colloquy was in May. The mother died in January of that year. Then May was the waiver colloquy, and then November was the penalty phase, the bench penalty phase. Okay, but I'd also like to read in Figaro. You relied on Ruiz, and Ruiz has a part that literally says where they're talking about that was the whole issue in Ruiz, how thorough a defendant's, how complete, in the words of the United States Supreme Court, a defendant's knowledge has to be. There, they didn't get Brady material for a fast-track plea. And the United States Supreme Court said fast-track pleas are still valid, even though you do not have much more relevant information, the information that the government's going to present against you. But in Ruiz, it says, in respect to a defendant's awareness of the relevant circumstances, it does not require complete knowledge, but it permits a court to accept a guilty plea, which is a form of waiver, with its accompanying waiver of the various constitutional rights. And here's the money quote: despite various forms of misapprehension under which a defendant might labor. And it cites Brady versus the United States, which is the case I relied on in my brief. Your Honor, it's pretty clear that even if a defendant, from this language, admitted dicta, but dicta from the United States Supreme Court, that a defendant, even a mistake of fact that's not related to the right at issue, a mistake of fact that's not related, that's a misapprehension, that's misinformation, but that is unconnected to the right at issue, does not render in that case it was a guilty plea, but does not render a waiver involuntary. They're literally, the United States Supreme Court doesn't care about other forms of mistakes that aren't related to the right at issue. I would like to point out also there is a prosecutor
Can I
wouldn't
ask you
really
quickly
have.
on standard of review, with that being your argument, do you still see it as abuse of discretion, or do you say regardless of how the court interpreted this argument, it would have been legally insufficient regardless of when the
As a matter of law, this claim does not give rise, cannot support an unknowing as a matter of law, but that does not change my argument. It's alternative. I think I went on both the facts and the law.
Thank you.
And this was a finding by a trial court that this was made in bad faith, that this motion to withdraw the prior waiver of the penalty phase jury was made, and here's a quote, in bad faith for purposes of obtaining the delay. And the record fully supports that. The trial judge really relied on two main reasons for that. One was the over 4 months, just a few days, over 4 months delay. And remember, this defendant was informed twice at the bench penalty phase by two different sources. The prosecutor, right after the judge asked the defendant to reaffirm his wanting to waive, literally turned the page. The next page, the prosecutor tells everyone in the courtroom that the mother has died. And then later, the grandfather of the victim, who is the father of the mother, in the victim impact that is being read to the court, that is also included in that letter. So two different sources at two different times tell him. And he has no trouble writing letters to this judge. This record is full. So I don't think, yes, you may want to talk to counsel, but that needs to be done very quickly. He should have asked for a break right then if this was his sole motivation. But I'm just saying the judge could say, even in response, if that had happened, that's not what the law cares. That's irrelevant, legally irrelevant to knowing. And if he wanted to enforce that waiver, he could. Just one more thing about Floyd. The argument here seems to be that the judge really did, not very many judicial resources were spent, because the penalty phase here was admittedly, because of both the waiver of the jury and of mitigation, was a very short thing. Basically, what happened was the transcripts from the first penalty phase came in for purposes of Mohammed, and then the victim impact letters were read, and they were going to let the defendant talk, but the judge said you can do that at Spencer. Admittedly, it was very short. But we do not redo entire proceedings just because they didn't take days and days and days. And secondly, we don't even know that's true. The judicial labor involved here, we don't know if Judge Patterson very well may have started reading the penalty phase transcripts from the first to start preparing his sentencing order. We have no idea how much. The only thing we know is the judicial labor that happened on the record. There may have been much more back in chambers, but regardless of how much time was spent, you do not redo an entire thing. I think this is the judge's findings that changing your mind and waiting 4 months is bad faith are completely supported by this record, and there is no abuse of discretion. When a judge has made basically a factual finding of bad faith that is supported, both those are undisputed. It's undisputed that this motion was 4 months late, really, and that the defendant had a history all through this proceeding of changing his mind. We ask you to affirm the sentence following the Hurst resentencing. Thank you.
Thank you very much.
Your Honors, regarding the defendant changing his mind, there is only one period of time during which Mr. Caylor's indecision about his waiving arguably caused any delay when proceedings weren't already delayed for other reasons. And that is the time period between when he found out in November that the victim's mother was dead and when his motion was filed. And I would, again, direct you to that summary of contacts with counsel and the defendant as evidence that this was not an unreasonable delay. It was not done for the purposes of delaying the entire proceedings. This motion was filed as soon as Mr. Caylor was able to consult with counsel about the consequences of what he had learned at the November hearing. I also want to point out that at that November hearing, he was told if he wanted to say anything, he could, but that he would be sworn and questioned and subject to cross-examination. And so it is understandable that he agreed to wait until the Spencer hearing. And in fact, this motion was filed in advance of the Spencer hearing being scheduled. I want to quickly go back to Floyd. When you remove the bad faith finding, which I don't believe is supported by the record or the chronology, Floyd says that the trial court's discretion should be exercised liberally in favor of granting to an accused the right to a trial by jury. That could have happened here. And our position is that it was an abuse of the trial court's discretion in the context of the way these waivers were made and then attempted to be withdrawn, to deny Mr. Caylor that jury for his penalty phase, which is a significant right, and one that he knew when he gave up he was basically acquiescing to the reinstatement of a death sentence. That was clear from the record. Floyd says that unless some real harm will be done, unless there will be real inconvenience to the court or the state, that the importance of the right to jury should lead the court to exercise its discretion in favor of giving someone a jury trial. And so if there are no further questions, Mr. Caylor requests